Hi, everyone. I'm Craig Wagner, and we have Lance Harrison. We're the attorneys for the Utah Association of Realtors, and appreciate all of you for tuning in with us. As with any sort of hotline that we have, you're welcome to type in any sort of questions you may have. Today, we are just going to talk about a couple of forms updates. They're not wholesale changes, really. There's some minor changes, but we wanted to make you, our membership, aware of these changes and really what does it mean for your clients, your buyers, and your sellers. So we certainly want to address those. So I'm going to share my screen and show the two forms that were changed. First is the buyer's due diligence checklist, and the second is the seller's property condition disclosures. So two forms that are used in, frankly, most transactions. I would imagine most, if not, all realtor buyers are showing their buyers, and then on the flip side, listing agents are showing to their sellers. So let me pull up first the buyer's due diligence checklist. So the only thing that's been modified on this is in section 19 or 18, I should say. Lance, would you mind reading that, and then we can maybe explain what exactly is a public infrastructure district?
Yeah, for sure. So yeah, this is kind of a unique thing that we can kind of go over. And basically it's a short section, as you can see. Buyer is advised to verify if a property is located within a PID or a public infrastructure district. Buyer is also advised that owners of properties located within a PID may be responsible for additional property tax obligations as a result of a PID issuing a limited tax bond. And then there's that citation that we can talk about a little bit.
Yeah, so a very small addition to the buyer's due diligence checklist. So maybe Lance, put you on the spot, but what exactly is a public infrastructure district, or maybe what is the purpose behind a PID?
Yeah, so a public infrastructure district, it's kind of this weird little thing, and that's why we wanted to talk about it today, to educate everyone on a little bit. And you probably won't see them very often, but what they are is basically an independent government kind of district or entity that's created by a county or a city through kind of a creation process, usually from a developer is petitioning them to create something like this for a public improvement of some sort. So something that benefits the public, and it's created by petitioning the city or the county, and then they have kind of a broad authority to whether to accept that or not. And then it gives authority to issue a bond or to raise money kind of like that. And then what happens is that they issue a bond, and then the members of that PID where that is effective have to pay that over usually between 20 and 40 years of repaying that amount. So we're not going to get into the details, but that's kind of what it is. It funds kind of a public improvement, and it's an entity that a developer can use. It's a tool they can use to fund that.
Yeah, so in the creation process, if a developer is looking to maybe fund the infrastructure of the development, so maybe the roads or the sidewalks or things of that nature, this could be a way to fund it without the upfront cost to the developer themselves. It does require, for the creation of a PID, 100% of the landowners within the boundaries of the PID, or in this case, the development. But that in and of itself does not create the public infrastructure district. As Lance correctly noted, it would then need to be approved by the city or the county in which the public infrastructure district is located. And it's at the sole discretion of the city or the county to approve or to reject the approving or the creation of the public infrastructure district. I mean, we're getting into the nuances here, but maybe we can take a step back, Lance, and maybe ask, well, why would a buyer care that their property or their prospective property that they're going to buy is located in a public infrastructure district. I mean, so what? Why would that matter to a buyer?
Yeah, I think the biggest reason is probably because it's a potential financial detriment to them if they have to pay something for the next 20 to 30 years, like it's a tax basically that they would have to pay. So it's just a notification that, hey, let's find out if it's something like that. What are the obligations, and could those obligations change in the future or not? Those are some of the questions that you might want to be asking.
Yeah, absolutely. I mean, that is the reason, right? Why it's in there is that there could be a severe financial obligation for a landowner located within the public infrastructure district to continue to pay back this tax bond. And like Lance said, it could be over a long period of time. So if it's a relatively new development that's only been in existence for a year or two, then there could be that continued tax liability to the PID for the development of the infrastructure within that spot. You'll also notice, and I do want to clarify, so you'll see the statutory reference 17D-4-101. So I want to pull up the statutory reference. Let's see. I'll do it from the division website, so maybe that's a little bit easier. So here you're on the division's website. If you go ahead and click on the Real Estate Licensing Practices Act, and then just go to the Utah Code, this is the entire code that's in existence for the state of Utah. So this is statute. When we talk about the code, we're talking about statute. This is going to be located, and this is where I wanted to clarify. So the statutory reference that is in the buyer's due diligence checklist is 17D. The reason why we put it as 17D, even though it's in 17B right now, is because this last legislative session, there was a tweak, a renumbering. And so right now it's currently in 17B, but it's going to be, and you can see right here, the note talking about how it's been changed, and it was changed to 17D. But right now, when you search it, it's going to be in 17B, but it is in 17D. And so we wanted to make it as simple as possible, but also get word out. So that statutory reference, it should be updated on the Utah State Legislature website that you see right now. I would imagine in a couple of days. It's been in existence and signed into law, I want to say back in March. So it's been in place for quite some time. But this is the statutory reference. This is where you can learn about the creation of a public infrastructure district. And this would be valuable to your buyers who just want to learn more about this, the creation of this type of district and what significance it has.
And there was a lot of substantive changes, right? It was just a renumbering. So if you do look it up, I don't think there's much risk of you looking at the old section and the old number. You can still get the current law there.
Yep, exactly. It was simply a renumbering. There was nothing substantive. And you can even see the status of this bill, this last legislative session. Really, it went through, and you can see that it's already been signed. It was signed on the 17th of March. And there hasn't been any updates since then. So we definitely wanted to have the correct statutory citation, and it is, but you're just not going to be able to find it based on that citation simply because the code hasn't been updated yet. So we've had a couple of calls about that, and I did want to clarify that point, that statutory reference in the buyer's due diligence checklist is correct, but again, it just hasn't been updated. So on the flip side, we also updated the seller's property condition disclosure form. So I'll go ahead and pull that up. So here is where a seller would disclose. And so you'll scroll down. It's a newer section. We tried to put it in a section that made sense. So you have the homeowners association section on section 21. And then section 22, public infrastructure districts. And as Lance said, many properties right now the vast majority of properties right now are not located within a public infrastructure district. So frankly, your sellers are going to mark no, and then they're going to mark NA, right? I mean, it's just not going to be applicable. But it is, our sellers' disclosures are they're definitely meant for right now, but they're also forward thinking of what things will become material information. And like Lance said before, this is a tax obligation that the buyer will assume going forward. So it is material. It is something that is important. And so it is requiring a seller to disclose these types of things. Now, Lance, maybe I can ask you, how would a seller know whether or not their property is located within a public infrastructure district? Is there a way for them to discover that, or would they be put on notice somehow?
Yeah, so I think there's probably two main ways. One, hopefully if you're a seller, know about it and are making payments, right? So that's one way. But the main way is probably that it should be recorded as a notice when it's created. So when you do a title report or a title search or a commitment, it should be noted on there. So that's something you can maybe talk to the title company about, but that's where it should be noted.
Yeah, absolutely. And that looks like it's one of those questions, is that, yeah, there's going to be a notice recorded, and that is a statutory obligation, that the notice is recorded within 30 days of issuance. It is something that would be recorded, so it should show up on a title report. So as the seller goes to sell, if they get the preliminary title report, it would be something that would show as an encumbrance on the title. Excellent. And those are the two changes, right? I mean, was there anything else you wanted to add about the seller's disclosures, Lance?
Yeah, I was just going to say they do have in the statute, like Craig and I just reviewed, that there can be additional assessments, right? A penalty if you're not paying those things. So it is serious to be careful of, but yeah, it's pretty rare. So
yeah, and we can get into the nuances of how they're created and kind of the ways that they could benefit a developer, but also, what latitude a city or a county has. I mean, if it's an unincorporated area, then it would be the county that would be approving in this case, the public infrastructure district. And the city or the county would have latitude, as we discussed, have latitude as the parameters of what the PID can be used for. So really, those are going to be things that in the approval process, as 100% of the landowners, which again, if the developer owns all the land, they just need their approval. In their petition to the city or the county, they're going to give kind of why they would need the public infrastructure district, and certainly the city or the county would do their due diligence as to approving. And again, statutorily, they have broad discretion to approve or to reject a public infrastructure district, and they have been used. Lance and I, we both kind of went through, because they're relatively new. They've been in existence for, I want to say, 2 years now, and we have seen instances where PIDs have been used to develop the infrastructure for development. And so they are being used. It is an additional tool for development in the state of Utah, but we want it to be completely transparent to buyers, and we certainly want them to be aware of something like this, that would be an ongoing obligation. Okay, excellent. Well, it looks like there are only a couple of comments. Hopefully we answered your question, Jennifer, and Chad, it looks like you would like to talk about a different legal question, so we can certainly address that later. I think that's it. This is a relatively short one. You can certainly share this video on Facebook, and we do hope on our website as well that you'd be able to search relevant legal topics like PIDs or seller's disclosures and things of that nature. Okay, well, until next time, feel free to tune in, and like always, you're more than welcome to call the legal hotline Monday, Wednesday, and Friday from 8:30 to 4. Thanks a lot. Take care.